Good afternoon, everyone, and thanks for joining the PCB regional webinars for DACH region. My name is Alex Carroll. I work at Tech GDPR, a boutique consulting in Berlin, Germany, where we offer DPO as a service, compliance assessments, a lot having to do with AI, of course, at the moment, with the coming out of the AI Act. We do some information security management system support with the implementation, for instance, of ISO 27001. And I myself am a PCB member. I'm very happy to welcome those of you who are members. Maybe we've met already in conferences, and also invite those of you who aren't members to join. This is a very valuable network to enter and exchange with like-minded privacy and security professionals. So the topic for today is balancing innovation and compliance, how to implement AI in alignment with the GDPR. To be honest, I work in data protection, so my point of view is very much that of protecting the data subject. But I speak with innovators, with developers all the time, so I do understand their questions, their concerns. I do understand the need to innovate. So what I'm going to do today is focus quite a bit on what innovators should know about the GDPR in order to deliver, let's say, innovative, modern, yet privacy-preserving products. So I'm going to be addressing the following points. We'll be looking at security and protection, specifically from the perspective of, I know I'm addressing a wide range of people right now on the call, right? So there's going to be developers, there's going to be business owners, there are going to be people in the EU, people not in the EU or joining from the US, for instance. And there's a lot of friction in understanding what needs to be done and what does indeed apply from different perspectives. So for me, what's really important, and this is something I've gathered in the last 6 years working with Tech GDPR, definitely there always needs to be a degree of alignment within your team and with your partners. So your clients, if you're developing solutions for them, or the other way around. So I'm going to be focusing a lot on concepts, on notions. I'm going to be referring a lot to these things, making sure that it's really clear to us what the GDPR expects. And I'm going to be raising a lot of misconceptions throughout the slide deck. So bear with me, because I'm probably going to address things that you already are familiar with, but I really want to make sure that you carry with you back into the conversations with your teams and clients what it is you need to align with, because these misconceptions can otherwise derail any projects. So we'll be looking at how the GDPR applies, what are different data protection roles, how that impacts AI implementation and development. We'll be looking at crucial to the GDPR, the ability to determine purposes, understand what is meant by lawfulness, because this is a term that comes over and over again. If you're familiar, or if you've been reading a little bit of information on the topic, the term lawfulness is probably quite misunderstood. What do we understand under the GDPR when we talk of lawfulness? Of course, we're going to be looking at data protection principles, how they apply, or where the friction lies with AI development and implementation. We'll be looking at training models and reuse of data. This is probably something that a lot of you are interested in. And I'll be referencing here practical guidance that was not initiated by a German data protection authority, but specifically by the French Data Protection Authority. So bear with me if I, although this is a DACH webinar, if I reference a French resource, because it does provide clarity as to how you as a data controller can exploit, make use of Article 6.4 of the GDPR. And of course, we'll end the webinar by looking at how you might get GDPR ready to implement and deploy AI. I want you to get familiarized with the three icons on the screen right now. This open book with a light bulb will indicate knowledge and notions that you should be really have a solid understanding of. The next one is concerned with issues that you will encounter in AI projects or when speaking with other stakeholders in the business. And the third one, this spanner and screwdriver icon, indicates solutions and approaches that you can take away and hopefully discuss with your team, see if they work for you. In any case, you can find me on LinkedIn, and I'm happy to support with further questions. Hopefully by the end of this webinar, you'll be able to better understand or better anticipate when data protection issues when sales, marketing, and product teams tell you, hey, we're GDPR compliant, specifically when product owners or sales team speak to you about their solutions. So be very, very careful when you hear that being said. Also, if the CEO, the legal department tells you, we just want to focus on how AI is implemented in our product, be careful, because AI tends to be implemented across the board. It also affects the privacy of your employees, your sales relations, your leads, website visitors, who knows? So be very careful about trying to scope compliance only to the product. I know it, in terms of resources, that makes sense. But to be honest, compliance doesn't see borders, and my best advice to management is always to encourage staff to handle data in a compliant way by first handling their data in a compliant way. So be careful about those limitations. So where and when does the GDPR apply? We often talk about the territorial scope of the GDPR. There are two criterion. There are three criteria that apply. The establishment criterion, this is stipulates that a company that's registered in the union is under the scope of the GDPR. If a company is targeting, which means offering goods and services to people in the union or monitoring their behavior, it also applies. So consider that somebody passing through the union, like a US citizen, while they're in the union, their processing of their data would be under the scope. Exactly how you would exercise your rights then is not entirely clear, but it's nothing to do with whether someone is a resident or a citizen of a country, of an EU country. It's being in the union that really triggers it here. And then the third criteria to consider is if you're offering goods and let's say data services from outside of the union to companies who are under the scope of the GDPR, specifically in relation to the 2 bullet points above, then if they're under the scope of the GDPR, then your processing of data will also fall under that scope. I hope that's a bit clear there. So be careful when you hear sales, marketing, and product team says, hey, we're a US company, so the GDPR doesn't apply. It really depends what you're offering to EU companies and if your audience is in the EU. Be careful when the CEO, the product owner, or the supplier says they're not in the EU. That doesn't necessarily, give them a blank slate for the use of data. And also be careful when MarTech and AdTech tends to bring arguments such as, we don't target or monitor behavior in the EU. We're not interested in the data. It's just passing through our system. To be honest, in order to route an ad to a specific user device, that's targeting, right? And that really triggers the processing of personal data. And I'll get to what constitutes personal data in a future slide, because this really has to do with aligning and making sure that we're on the same page when talking about whether the regulation applies. So one thing that's maybe very clear to most of you, but still I find that misconception rampant in most discussions, is the relationship or the difference between information security and data protection. When you look at it from the surface, they do look like synonyms, but that's not the case, right? Often, if you ask a supplier, are you compliant with data protection? The answer comes fast and they say, yes, we're ISO 27001 certified. And that's really different scopes. So let's have a look. Information security is the protection of data assets of an organization. Any information assets, really anyone that is worth protecting, will be covered under information security. Not just the data itself, but the software assets, the hardware assets. Now, if you drill down to personal data, this is where data protection comes along, and it's the legal aspect of providing rights to fundamental rights, providing fundamental rights to people in relation to how their data is used and misused by corporate or public organizations, right? So within information security, a subset of data will be personal data, and then the legal obligations derived from processing that data or available to data subjects in relation to how that data is used is what constitutes data protection. What they have in common is compliance, and compliance could be defined as the demonstrable fulfillment of requirements. You have statutory compliance, think of the GDPR, think of the new AI Act, but also legal compliance could be that of contracts. And you have normative compliance, such as ISO 27001, which is Information Security Management System, 27701, which is an extension of that framework that governs personally identifiable information. So not ISMS, Information Security Management System, but PII management system. And then you have ISO 42001, which is AI management system. So this you should keep in mind, because depending on which stakeholder you're talking to, the confusion is still there. Other misconceptions that you should be careful about. Well, let's look at personal data. In North America, in the US specifically, the term used is personally identifiable information. In the EU, as defined in Article 4.1 of the GDPR, we talk of personal data. To be honest, PII, or the definition that I could find of PII on the website of the US Department of Labor, is very much in line with that of the GDPR, personal data. They're both aligned on the fact that it's any data, that it's directly and indirectly identifiable data. It also refers to online identifiers and pseudonyms as still being personal data. So why is it that US, when we speak to people in the US, I see it on a regular basis, the notion of personal data is different? Well, I think this, and this is really personal here, I think that this has to do with a dangerous emphasis within the definition. There is an example of strong identifiers, things like email addresses, right? My name out of context is not enough to identify me, so that's probably not a strong identifier. But an email address, a phone number, a social security number is extremely identifiable information. It's a unique identifier, strong identifier. And because these are in the definition of PII, that's what corporations tend to remember. That is what personal data is, or PII is. But to be honest, they're pretty much the same as personal data in the EU. It's any data that directly or indirectly can identify someone. Adding to that confusion is the HIPAA, Health Information Protection and Accountability Act, if I'm not mistaken, in the US, that provides technical means of de-identifying a data set by removing 18 points within a data set. You could claim, from a legal perspective, you can claim that that data is anonymous. That's probably what increases misconceptions between EU and non-EU companies. Right, so be careful if you hear a CEO, a head of product, or a supply say, we cannot identify that data. We have no means of figuring out who's behind that pseudonym. So that's good enough, it's protected. In fact, no, pseudonyms are still considered personal data under EU regulation. Now let's look at the terms, terminology, synonym, anonymous, anonymized, anonymization. Anonymous data from an EU perspective is even defined in the GDPR as data that cannot help identify someone. You cannot re-identify someone from anonymous data, let's say. And in practice, what is commonly accepted as a good definition of anonymous or a good threshold of anonymity is if the data is aggregated. Now, if you're training AI, you can't do much with aggregated data and statistics. You're probably going to need raw data. So forget anybody telling you that the data is anonymous in the context of training AI. I mean, if it's not related to an individual, perhaps, but it's very difficult for data not to be related to someone or help identify them at some point. Even IoT data might somewhere be related to the owner of the device, to the maintenance team behind the device or person, and provide a lot of behavior data, to be honest, around the context in which it's implemented. So be very careful about people arguing that data is anonymous. Now, another synonym that's confusing is pseudo-anonymous. What's meant by this is pseudonymous, and pseudonymous is basically when you have an identifier in place of a strong identifier. But even hashes, which you cannot calculate backwards, are to be considered pseudonymous. This was actually interestingly confirmed by the Federal Trade Commission. They have a team of scientists that did a nice blog post. If you're interested, link up with me on LinkedIn. I'll send you the resource that no hashing does not make data anonymous. And it makes sense, right? If you take my name and you hash it and you compare that hash with a hash existing somewhere, and the comparison is valid, then you have you have information that wasn't initially meant to be identified. So be very careful. Interestingly, in Germany, a few years ago, the Federal Data Protection Authority, so the mother organization behind the 16 Länder, did do a press release indicating that anonymization itself, the activity of anonymizing data, is a processing activity that requires a legal base. It makes you a data controller if you're doing it, and it requires a legal base. Now, it's weird because the output of anonymization is anonymous data. It's not in scope of the regulation, but when you think of it, in order to anonymize data, you need access to raw data in the first place. So that process is what triggers GDPR requirements. Another concept that we often hear about is sensitive data. It's not really a term that's in the GDPR, but very much used in Anglo-Saxon countries. Yeah, I mean, the GDPR doesn't specifically talk about banking information, but you could consider that to be sensitive. The GDPR in Article 9 does highlight special categories of data, and those include racial, ethnic origin, opinions, beliefs. Now, genetic, biometric data, if it's used to identify somebody, will be a special category of data. So for instance, if you're capturing images and submitting them to facial recognition, that is biometric, that is special category of data. You're triggering requirements under Article 9. But if you're gathering images and not submitting them to biometric recognition, then it's not specific categories of data. And to be honest, some people might disagree. I got the confirmation of this by literally phoning data protection authorities in France and the UK. So I advise, and I'll get to that later, for you to do the same. And then think about it as a data subject. You have apps on your watches, on your phones that monitor your heart rate, the number of steps you're taking. This is health data. How many of these apps have actually asked you for explicit consent, which is the only way that you can legitimize processing of special categories of data? Now, if the term legitimization is a bit unclear to you, we're going to get this. What's really central to the GDPR is understanding the relationship between a processing activity, the fulfillment of a purpose, and the legitimization of that activity, or that business purpose. And okay, right now we're looking at a circle, but to be honest, a triangle is about to appear. I like to call that the holy trinity of data protection, of European data protection. It's the relationship between processing activities, business purposes, and legal bases. A processing activity satisfies a business purpose, and the business purpose dictates what available legal base you can choose from. Right? I'll just throw in a word that everybody's familiar with. Consent is the legal base, but consent doesn't work in a lot of cases, or shouldn't be used in a lot of cases. So figuring out which legal base to use to justify the business purpose, to legally justify it, so that you can demonstrate that the processing is lawful, is something that all companies struggle with. And if you have started your compliance journey and you have a fairly robust ROPA, records of processing activities, that's Article 30 of the GDPR, which is really your core compliance exercise from which everything else derives, then you will know that it's a difficult exercise to split activities into purposes or deduce purpose, create activities from purposes you want to achieve, label them properly, and then properly legitimize them is the difficulty. Now, legal bases are important because choosing the right legal base impacts the exercisability of the rights behind it, right? For instance, the right to be forgotten under consent is actually the right to revoke consent, and that comes with conditions, like it's got to be as simple to revoke it as to provide it. In fact, with consent, you should be able not to provide consent if you don't want to. So you already get a sense of misimplemented processing activities where companies ask you to accept the terms and conditions. You've probably seen this on AI solutions and websites and their privacy notices or privacy documentation that says, hey, accept the terms and conditions and the privacy notice. First of all, you never have to accept the privacy notice. It just exists. It's there for your information. There's no need to accept it. Accepting terms and conditions, yes, but not the privacy notice. And what if you don't want to consent to the processing of data for specific purposes? You should be able not to. So if you're forced to, then that is not valid consent, at least under EU law. Business purposes indicate having defined a business purpose will lead you to defining retention periods that are adequate. Okay, I hope this is more clear, but if you understand this holy trinity, plus the principles of data protection that we're going to get to, you understand 80% of the GDPR, and you're on a good way to getting your AI implementation or AI development compliant. Data protection rules, you're familiar with this, no doubt. Data controllers are organizations that set the means and purposes for processing. So the purpose, again, is a business purpose. It needs to be defined, needs to be communicated. That's what leads to things like privacy notices. And the means is, how are you going to process the data? What technology stack are you implementing? What AI solutions are you implementing in order for the processing to take place? That is determined, or the organization that makes that determination is a data controller. Processor, however, is a company that will process data on behalf of the controller. And that's pretty much the conceptual difference that you need to wrap your heads around. Luckily, we're talking about AI today, not about blockchain, because the relationship between controls and processors on blockchain in blockchain scenarios is slightly more tricky. Decentralized applications, that's a sort of controllership issue that's difficult to determine. But looking at AI, two things to remember here. If you're a processor, let's say you're developing applications or supplying an AI piece of software to a company, make sure you don't process the data that your client gives you for your own purposes. That makes you a data controller. You'll have a data processing agreement appended to your master service agreement with your client, with your data controller client, no doubt. But that documentation alone does not determine whether your controller or processor, it writes it out for clarity, but it's essentially in practice, what do you do with the data? And if you use it for your own purposes, and be very careful because processors have their own purposes very often, for instance, figuring out what aspects of their products is most used and how to improve it. So you have statistical analysis, that sort of thing. That's your own purpose, and that probably makes you a data controller. Well, it does, and the problem with that is that you then are in a position of being a controller without performing all your obligations, such as the duty to inform and exercisability of data subject rights. So it's what you do with the data that makes you a controller and a processor. And in fact, we tend to bucket companies. We say this company is a processor, AWS is a processor, our company is a controller, for instance. It makes conversations easier, but in fact, it's down to the single processing activity. You can either be one or the other. And if you're two organizations that have similar needs for the same data, then you're likely joint controllers. And this was the case, specifically Germany was good at providing guidance there on implementation of social media. For instance, the Facebook like button makes you a joint controller with Facebook because both your organization and Facebook have interest in using that data. I hope that's clear there. Now, keep in mind that it's the data controller that sets the legal base, right? Because the data controller defines the purpose. So the data controller sets the legal basis and the retention periods. And all of this is clarified in the privacy notice. The processor does not have to do that. In the scope or in the context of developing AI, let's say sourcing training data for a development of a model, then you're definitely a data controller if you're processing your own data, because implementation or development of the AI model will serve your own purposes. It's your data, it's your purposes that makes you a controller. Sorry, the purposes part, not so much the data. You're a data controller if you're processing third-party data, for instance, data you've sourced from data brokers. Now, the compliance aspect before you get that data is the data broker's problem. But once you have that data in your systems, you have access to it. You don't even need to have a copy of it, but being able to download it, let's say from the data broker's server, is already could be seen as an international transfer if the data is between two different jurisdictions, EU and a non-EU company. So be very, very careful with that. If you do get data from a third party, then you have 1 month to perform your obligations to inform data subjects. You'll find that very clearly written in Article 14 of the GDPR. You're a joint controller if with another company you're jointly processing data. You're definitely a data controller if you're processing publicly available data. My data on Facebook was my choice to put it there, but I'm not giving green card or free reign for all companies around the world to do what they want with it. They're probably doing that anyways, but I can exercise rights against them. One up for me. Right, publicly available data, that's another misconception. It's not because it's online that it can be misused. And you're a data controller if you're processing, your data processor if you're processing data controller data and not using it for your purposes. In the context of implementing AI, keep in mind that a data controller owns the relationship with the data subject. So the transparency, the lawfulness is within, again, sits with the data controller. That's the line at the top there. And if you're a the data controller, instructs the data processor, and this is reflected in the data processing agreement. It's to be seen as an instruction, although in practice, the processor tends to be many times bigger than the controller. So it's the processor that's actually providing the controller with the DPA to be signed. But in the end, the responsibility and liability of implementing the right or the risky processor sits on the lap of the data controller. So due diligence, definitely. And in fact, that's where I'm getting at. Make sure you carry out due diligence in your documentation. Document your choices that will satisfy the accountability principle. Align with your teams and with your customers. Check in with your DPO because they know a thing or two about data protection. Yeah. And if you're developing AI, then I suggest you, and that's the thing, right? Developing AI as a, let's say, an AI development agency usually comes with clients who have a fair idea what they want to achieve. They give you access to all data and say, hey, be creative, work your AI magic on this data, give us some insights. We don't really know what we want to achieve, but you'll help us figure it out. Be careful, because then it can be argued that you're determining purposes on behalf, well, at least on behalf, not, but you're making decisions on as to the purposes. That would make you a controller. So what you need to do is maybe break down your AI development process and have close feedback loops with your data controller to update the DPA, data processing agreement, with the new activities, the new purposes for processing the data for them, if that makes sense. Right, data protection principles and friction with AI development and implementation. We've just talked about lawfulness, fairness, and transparency work together. Transparency is people need to be aware of what's happening with the data. And the problem is that if you want to submit AI data to AI, it's probably not been anticipated 10 years ago when the data was first collected for a specific purpose. Purpose limitation stipulates that you process data for a given purpose. If you have two purposes, then there's two activities and you need a legitimization for both. Data minimization stipulates you only process the minimum amount of data for your purpose. So the problem with big data and data science is the more the merrier, right? So that's already a clear potential violation depending on how you scope it. Accuracy, you're familiar with that. If you're into security, in fact, integrity and confidentiality, point F here, you're also familiar with, because that's two of the information security goals. Storage limitation works really well with purpose limitation. It stipulates that data should not be kept longer than necessary, and the necessity is determined by the business purpose. So once data has served a purpose, it should be deleted. There are workarounds, and if you have questions, feel free to reach out, and companies are pretty creative with those workarounds. But if it's documented and lawful, then those workarounds are actually new processing activities that are definitely compliant. There's the principle of accountability. If you're into ISO norms, that you completely understand accountability. It's how you can demonstrate that you've implemented these principles and other responsibilities or obligations. And then privacy by design and default, which stipulates that when you roll out a product or a service, you need to have incorporated privacy data protection from the outset within the design stage, and that you roll out a solution with the most privacy invasive features turned off by default. So the problem here is, and I'll probably go through this really quickly. Feel free to take a screenshot, take that with you, and test yourself whether you can map the problems on the right side of the screen to the principles on the left side, right? Are data subjects made aware that's a problem of transparency, that you're submitting their data to AI or using it for training? What else can I point out really quickly here that's of interest? Yes, can you segregate development and production environments? Because that might affect the principles of integrity and confidentiality, right? Providing access to a development team of production data might come with some risks that you can easily avoid by segregating the environments, for instance. Still, making a copy of the data and providing it is a processing activity. You're gonna have to legitimize this, but at least you can argue this is a technical organizational measure to protect the integrity of data. The third one from the bottom there is interesting. Can anonymization be used? Again, I don't think you can do much data science with aggregates. So simply stop talking about anonymization. Be at peace with processing personal data and the regulation that comes with it. And to be honest, you can't figure it out in a couple of weeks. It might take a couple of years, but it's a journey. And yeah, there are resources and people to help you there. Be at peace with it. Right, and if you can do away with personal data altogether and use synthetic data, then that would be great for training or rolling out AI. Again, what I mentioned a moment ago, model training is usually an afterthought, so it's rarely ever legitimized. It's unlawful. That's what we mean by unlawful or legitimized. Remember that the controller defines the legal base for each processing activity. So think of sharing data as a processing activity, or submitting production or live data to an algorithm is also a processing activity. It needs a purpose, and the purpose comes with its lawful base. Sharing with outsourced developers to achieve specific outcomes that you need to be very clear about as a controller requires a purpose, and that makes its way into your records of processing activities, into your privacy notice, into your DPA. You need full control over that trickle-down compliance effect. Think granular. Each processing activity serves a purpose, and each purpose is legitimized with its own legal base. And I often hear that people, even business owners saying, yes, we got our user data with consent, or we can do what we want with it. No, you got consent for a specific purpose. You cannot do what you want with it, but just that purpose. Hope it's starting to make sense. And what are these different legal bases? I talk of lawfulness, but the term legal base, legal basis, legal bases, plural, legitimization, lawful ground, lawful basis, they're all the same. It's all about Article 6 of the GDPR 6.1. How is data legitimized? Now, the problem is from a US perspective, we've got this simplification effect that revolves around consent, right? Consent is in fact a pretty good legal base in most cases, because in order to get consent from a data subject, you need to provide them with information, which makes sense, right? Hey, this is who we are and this is what we need your data for, so please provide us consent. It's a little bit more subtle, however, in the EU, because there are 6 legal bases. There's consent, there's performance of a contract, there's legal obligation. I'll skip the next 2 because they're very rarely used, at least vital interest, life and death situation. Public interest is dictated by public authorities, such as COVID contact tracing, for instance. You don't choose this, it's imposed by some legal framework, right? Forget D and E, but the last one is legitimate interest. So let's quickly about legal obligation. It's basically things like tax obligations. You can share, you need to share invoices or retain invoices for 10 years in Germany to demonstrate proof of sale. That's a legal obligation, and it comes with its own retention period. Easy. You need to transfer the payroll information to the tax office. That's legal obligation. In fact, in Germany, it's okay, it's an obligation to ask an employee when they sign up whether or not they are affiliated with the church. That would actually be a violation of Article 9, but it's in member state law, it's the local requirements, it's a legal obligation. You can ask that because it has implication on tax taken from your salary. So definitely asking somebody when you're onboarding them whether they're affiliated with the church is a legal obligation. It's not the case elsewhere though. So let's focus, because legal obligation is dictated by law. Let's just focus on A, B, and F, which are the 3 legal bases that you can choose from, that organizations can choose from. You've got consent, but the problem with consent is on the front end, it needs to be informed. You need to know what you're consenting to, what purpose you're consenting to. It needs to be specific. If they're 2 purposes or more for using the data, then it needs to have 2 tick boxes or more, which is why on cookie banners that are well implemented, you have that breakdown between categories of purposes. That's sort of accepted. It needs to be freely given. If I don't want to give consent, I can continue using a service, and most companies don't get that. So a website that tells you you need to consent to these cookies in order to access these resources, that's a clear violation. Now, in case law, especially it happened in Austria, it happened in Germany, now we have this consent okay or pay approach, where if you have a paid alternative, for instance, for accessing resources online, and the pricing is reasonable, then it's considered okay. Well, okay. I didn't make it up, but now I have to do with it. So freely given means that you can proceed without giving consent. If your company cannot afford not to get consent, then consent is not the right legal base. End of story. Unambiguous means that you cannot imply consent, or consent cannot be implied from, for instance, continuing to use a service or continuing to browse a website. You need to actively take in, for instance. On the back end, it needs to be revocable. You need to be able to take away consent, and it needs to be demonstrable. Think of consent as an opt-in. The data subject is opting in to the use of their data for a specific purpose. And then that leads us to looking at legitimate interest. Legitimate interest is the legitimate interest of the controller. It can be carried out, processing can be carried out if it's fairly balanced, if it doesn't outweigh the right of privacy of an individual, but it comes with the right to object, which could be understood as an opt-out. So consent and legitimate interest are good complementary solutions. It's one or the other. But they're usually difficult to implement. And if you're using legitimate interest, relying on it, then you have to carry out a legitimate interest assessment. There's some excellent guidance by the EDPB around that. Performance of a contract is if your company as a controller has a direct relationship with a data subject, you can rely on performance of a contract. But if you're trying to satisfy a contractual obligation with another company by using somebody's data, that's probably legitimate interest. For sure, not performance of a contract. Okay, let's look at some guidance from the French Data Protection Authority. And I'm sorry for the dark people who might be frustrated here, but I'll be honest with you, the French Data Protection Authority is extremely practical with its development of resources for developers and for technologists in general. If you think back to the purpose limitation principle, data cannot be repurposed. So what do you do if you have a database that was initially lawfully assembled, lawfully from data that was lawfully processed, and now you want to reuse it for training a model? That's what the CNIL has in July of this year looked at. And it's an interesting, useful guidance on interpreting how to utilize Article 6.4 of the GDPR. The CNIL says basically that defining a purpose in too general terms will not do. For instance, saying the development and improvement of an AI system is what we're trying to achieve is too vague. It's only to be considered determined, explicit, and legitimate if it's precise, and precision comes with considering the type of system developed. Is that made clear to the data subject in an intelligible way? So be careful, right? Privacy notices need to be readable. They're not an exercise in legalese, they're an exercise in transparency. It's really a communication exercise. It's got to be clear and intelligible in your privacy notice. And then you also have to consider the technically feasible functionalities and capabilities. Can you draw that list up? Can you reasonably foresee them, and can your data subject reasonably foresee them as well? Now, as public interest around AI develops, you can assume that this reasonable foreseeability is going to develop over time. But right now, I wouldn't be so sure about it. Think of LinkedIn recently that was discovered to submit your input to its AI algorithms. And it did this by informing you somewhere tucked away in a email communication, transactional email, maybe a newsletter. What it should have done is provided a very clear information that it was in its legitimate interest to do so, and given you the right to object, to opt out if you followed the previous slide. So in terms of solutions, well, document your choices. Again, accountability is central here, Article 5.2 of the GDPR. Update your records of processing activities, Article 30 of the GDPR, whether you're a data controller or your processor. Carry out due diligence on your data processing agreements, on your vendors, whether you're a controller or a processor relying on sub-processors, and update those documents when they need to. Specifically, if you're a controller giving data to a processor in order to create innovative solutions, those solutions need to define a clear purpose. And this is what the CNIL was concerned about. All supervisory authorities concerned about. Again, on the CNIL, and we're slowly reaching the end of the presentation. Article 6.4 covers things such as reuse of data. Now, the reuse of data for another purpose by a data controller is possible in three conditions. Either the data subject has provided consent for that purpose. Okay, lawful. That's the first of the three legal bases you can choose from. Or it's dictated by member state law. There's nothing you can do there. Or you have, or the application, let's say the design, satisfies a compatibility assessment. And that assessment must consider if there's a link between the initial purpose for the collection of data and the secondary purpose of that data. And that really works in the context of collection and reasonable expectation. So between a data subject and a data controller directly. If you're a processor, well, you could be instructed to get that data or reuse it, but that needs to be in the DPA. But usually it has to be a clear direct relationship, such as that of the controller to subject relationship. You need to consider the nature of the data. If you're dealing with special categories of data, health data, or worse, criminal data, Article 10, your compatibility assessment will fail. You need to consider the possible consequences for data subjects of this further processing. Now, specifically with algorithmic decision-making, if those decisions have a legal effect or significantly impact the data subject, such as profiling, I'm quoting from the GDPR here, then again, your compatibility assessment will fail. And consider the existence of appropriate safeguards. And specifically, what the CNIL points to here is the technical safeguards of encryption and pseudonymization, which are, along with access controls, probably the only three technical measures that are written out in the GDPR, to be honest. Now, another extension of this use case is the processing is presumed compatible, meaning there is no need for a compatibility assessment if the data is used for scientific and research purposes. And that works if, first of all, it complies with the GDPR, meaning the data processing is lawful to begin with. Remember, Article 6 lawfulness. If the data is not used to make decisions regarding the data subject, so impacts on the individual, but also consider that the right to object must be available. Sorry, I got my timer rang here. I'm a bit confused. So the right to object must be available. And I'm deducing from this that if there's a right to object, then the legal base suggested is legitimate interest, Article 6.1F that we saw in the previous slide. You also have to make sure that the duty informed is fulfilled, and keep in mind that covert secondary uses are not compatible. So Scientific and research purposes, yes, but looking at what you need to do to get GDPR ready to implement AI, and the next slide, to develop AI. Well, the good news is the GDPR is risk-based. So if you are ISO focused, you probably have risk assessment. You can expand on those risk assessment to create data processing impact assessments, to determine what are your appropriate technical organizational measures to protect data. Make sure you stay in touch with industry threat intelligence and have good knowledge of common errors, common knowledge, good common knowledge on human errors, because most of the breaches do not come from cyber attacks, but from humans making mistakes. Ask yourself and your team whether you have full overview of your data assets, your special categories of data, of your risk assessments, whether they're done prior to rolling out the solution or during and after data breaches. Ask yourself who owns the ROPA. Is it updated often enough? And does it and the privacy notice clearly document the purposes and legal basis? If that's in place, you're well set up to be compliant, AI or not AI. And you're not alone. So there are risk frameworks, there are AI frameworks, there are impact assessment frameworks, there are vendor assessments that are available to you to determine the risks that you inherit from your supply chain. There's a whole bunch of guidance from the European Data Protection Board, which is the mother organization comprising members of all supervisory authorities across Europe. There's case law, and there's a bunch of newsletters that will give you, that will, for instance, help you when you're reading them, put in context the terminology that we've reviewed extensively in this session. And to be honest, something that we don't think about is pick up your phone and reach out to the supervisory authority. They have hotlines, most of them, and they're very happy to help data subjects, companies, and DPOs. Make use of that, and most often I've never had the experience of them asking me to identify myself. Right, any questions? Probably a lot of questions. Okay, let me see, what do we have here? Data controller to data processor. Are postal services to be considered? There are different opinions, definitely. I'm not an expert and I'm not a lawyer, but what I can tell you that I understand about that is that there's a legal framework, there are rules around confidentiality. So if you seal an envelope and you post it, it's then a crime to open it and to get access to confidential information in it. So somebody delivering post should not open it. That would be a clear violation. As such, you don't need a DPA with a postal service because the data is not meant to be, the information is carried, but it's not read. It's not meant to be read. I hope that addresses the question there. Another question? Probably have to minimize this. What are the main GDPR rules to keep in mind when using AI? Well, I hope it was clear enough, but transparency. Transparency goes hand in hand with lawfulness. If you're covertly processing personal data with AI, I hope you're doing it not just for the fun of it, but to achieve a business purpose. So if there's a business purpose, it's fairly easy to determine what the lawfulness, what the legal base should be behind this. And you don't have much choice, to be honest, consent or legitimate interest. But in either cases, you cannot get consent from somebody who does not know the processing is happening. And if you're implementing legitimate interest, which to some extent, which will take place without how can I say this? If you're implementing legitimate interest, the data subject has the right to object. So then you can't do it completely covertly. You need to say, hey, this is what we're doing, or this is where we got your data from, and this is what our purpose is. Are you okay with this? And if you do this correctly and the right to object is not formulated, then you can go ahead. In fact, the interesting thing about legitimate interest is that if somebody objects to that processing, you can override the objection, but be careful because it's going to generate complaints. Those complaints lead to communication to the supervisory authorities. And the first thing the supervisory authority is going to ask you is, have you carried out an assessment to determine if your legitimate interest as a corporation or even a public institution outweighs the right to privacy of the individual? And that takes the form, again, it's a it's an exercise in communication. It takes the form of a legitimate interest assessment. If you're curious about this, get in touch. We'll help you there. Third question: what tools or frameworks can help ensure AI models comply with the GDPR? Good question. There's a flurry of frameworks. Look at OECD principles around ethical AI. Now, ethical does not mean GDPR compliance, but it sure pretty much includes it, because part of the ethical condition is that it's lawful. So, and because GDPR is a lawful framework, so legal framework, there's going to be focus there on lawfulness. There's a huge amount of frameworks around, again, ethical AI development, around GDPR compliance. I mentioned earlier, there's a lot that was done and is being done by the French Data Protection Authority. The Norwegian Data Protection Authority has also provided, a long time ago, 2019, some guidance on AI. But the French, and in fact, I probably skipped this on the previous slide earlier, but there was a couple of interesting in Germany from BSI, the Practical AI Security Guide of 2023, and the Security of AI Systems. You can Google those and they'll help you. And we may have time for a fourth question. Yeah. Probably we do. Fourth and final question: how can small businesses safely implement AI without risking non-compliance with the GDPR? Yeah, very good question, because often compliance is measured by the amount of effort, right? You're more compliant if you put more time in it, but time is money. For a small business, how do you do that? Very good question. I would say be super clear internally and user-facing. So it could be your employees, it could be on your website, it could be on your shop. You could have a poster with basic information on how you use data, what you use it for. I mean, to be honest, the GDPR is written in plain English. You don't have to be a lawyer to understand it. It's available online, and there's a handful of articles that you should read. Read Article 5, 6, 13, 30. I'm probably missing some, but if you understand these, you are 80% of the way there. And supervisory authorities have limited budgets. They're not going to go after people trying to get it right. They are going to go after they're more likely to go after big companies purposefully not getting it right. But when you look at enforcement actions, you see a bit of both. You see big companies getting fined. Clearview AI by the Dutch authority, 32 million for constituting a legal database of facial recognition of Dutch citizens unlawfully, because these Dutch citizens didn't know about it. That's one extreme case. On the small end of the enforcement fines, you'll find small companies being fined 1,000 euros, 5,000 euros for not being clear enough. So update your privacy notice. What do you need data for? And this is completely what you need to put in the privacy notice is outlined in Article 13. Anybody can read it in about 35 seconds. Implementing it correctly may take a lifetime, but start early and get help. We're there to help you. Thank you so much for joining. Please join the PCB network. It's a great environment to get cutting edge information in security and compliance. Join my network if you have questions. Reach out to Tech GDPR if you would like support. We also offer free calls. God bless. And yeah, have a great week. Have a lovely Christmas. Bye-bye.